I'm going to talk to you today about fines and penalties for following too closely in Ontario. I'm going to give you two common scenarios when this charge shows up at one of my offices. So the first example is and probably the most common example is an accident. And in that accident, let's say there's a vehicle at a traffic light and it's come to a stop, and the next vehicle that comes along behind does not stop in time and rear ends that vehicle. We're talking about seconds, okay, a very short period of time. And in that scenario, there's two drivers, one the stopped vehicle and the other vehicle who is charged with following too closely. Now, technically, they were driving down the road together. The one arrived at the traffic light first, stopped. The other one failed to do so, and there is some sort of collision, minor collision, and as a result of an accident investigation, the officer takes a look and says, well, you were simply following too close. Here's your ticket. In that particular case, the evidence of that accident is significant. It's significant in creating a defense to help that particular person who was charged. So in order to prove that case, you would need, or the Crown would need, evidence that the two vehicles were moving along together and they were within, I say a car length of each other, and they were going a certain speed. So basically what I'm telling you is time, speed, and distance are all things that would need to be included in the evidence in order to support that conviction. So to be convicted, you would need to hear that evidence in the courtroom. In the particular scenario that I've told you about, you have a vehicle that stopped at the light, looks ahead, and then bang, feels a bump from behind. In that particular scenario, the driver of that vehicle cannot provide any evidence of how close the second vehicle was, cannot provide any evidence of the speed of that vehicle or how close it may have been following that vehicle. And in those types of scenarios, and there are many of them, the reality is that case cannot be proven. And when those cases cannot be proven, the result is that the charge is dismissed. Many astute prosecutors, once we've identified for them that this is what's gone on and they do not have any evidence to support the charge, will withdraw. In the cases where they're not sure and they do run that evidence, there would not be a conviction. The second type of violation is a little different. That would be two vehicles driving down the road, and now those vehicles are being observed by a professional witness, such as a police officer. That police officer is in a position to view what speed those vehicles are going, the distance between those two vehicles, and for how long those vehicles were that close. And in that case, there's very good evidence of a follow too close charge, and if believed in a courtroom, there would be an obvious conviction. If there was a conviction, it would be under Section 158 of the Highway Traffic Act. The fine for that particular offense is $110 with costs. However, there are 4 demerit points with that particular offense. 4 demerit points often cause a lot of harm to insurance rates, leading to higher rates and stress among clients if this were to happen. If you were a novice driver, novice drivers have a very limited number of points to deal with. And if a novice driver, for example, got 4 points from that type of a conviction, they would also face not only the fines, the points, but they would also experience a 30-day license suspension, which would be identified on their abstract or record. And if that's seen on their record, the suspension and the conviction count as 2 separate things, and that escalates insurance rates significantly, and in many cases results in that particular defendant not being able to drive because they simply can no longer afford the insurance.